And a good snowy Friday morning to all of you here in Brooklyn, Arkansas. I'm Jackson Mitchell, joining you here from Brooklyn News headquarters, where we are following breaking news. President-elect Donald Trump appearing in court today virtually from his Florida home, Mar-a-Lago, on that case as he's expected to be sentenced for 34 felony counts of falsifying business records in the first degree. That hearing already underway, and as we come on the air, we're also monitoring the beginning of the arguments of TikTok versus the Attorney General Merrick Garland of the United States. That will all begin at the top of the hour. We will listen into that. We're monitoring a lot of events this morning. That is a feed on the left side of your screen, the live in New York, as we are expected to see or have an audio recording, I should say, a little bit later in the day. Could be put out and rendered today. We're waiting for that. If it happens, and we'll go through that and break that down for you. But court already in session there in New York. I want to go through here just a thread of what has occurred within the last little bit. So Judge Juan Merchan has essentially already said what Trump will be sentenced with, and that will be an unconditional discharge. So essentially, a conditional discharge is, hey, you're kind of on probation a little bit, but an unconditional discharge means you have a sentence, but you also don't have a sentence. You don't have parole. You don't have someone you have to report to, or anything of that nature. So Trump essentially being let off. But the lengthy part of this hearing of the sentence hearing is expected to be when Judge Juan Merchan has to explain why he is giving Trump this said unconditional discharge. This unconditional discharge. So essentially, your sentence is no sentence if you are charged with an unconditional discharge. Now, Merchan will have to say why he is giving that sentence. That's expected to be the lengthy part. The Manhattan District Attorney already saying that is what they want the president-elect to be charged with, and we're learning Todd Blanche. Also, if I'm correct, you're appearing virtually because we can see Trump and Blanche clearly inside that courtroom above Merchan's head. And let me just say this. Merchan asked Blanche to confirm receipt of report, which he has in front of him in Florida. Some of the facts and the prosecutorial history of the other cases are not up to date. Blanche says, but nothing else to put on the record. Basically asking Joshua Steinglass, who's been arguing for the Manhattan District Attorney here, the District Attorney's office, saying that he has nothing else to add. Either Steinglass is up and says Merchan can impose a sentence, quote, from prison to variety of non-incarceratory, forgive me if I'm saying that wrong, sentences, end quote there. And due to the quote, this is Joshua Steinglass here arguing for the Manhattan District Attorney's office, going on to say, quote, unique posture and defendant status as president-elect. So essentially, Joshua Steinglass here saying that the District Attorney's office understands if Judge Juan Merchan, the judge presiding over this case, decides that he wants to charge Trump with this unconditional discharge, which in a rare kind of moment here, Judge Juan Merchan has already said that's likely, very likely, I should say, to be his charge. So we're taking a look live on the left side of your screen there in New York, but we are also monitoring this argument that is fixing to begin here at the top of the hour, 8:56 now, 4 minutes till the argument for TikTok versus the Attorney General. I want to just go over what's happening with this argument and break that down for you before we listen into that, bringing you guys up to speed on what we do know. So the Congress and the president signed this. Congress passing a bill that says that TikTok, the application used by over 170 million Americans, must sell to an American company. And they claim that its parent company, ByteDance, a Chinese-owned entity, I should say, could possibly have a foreign, I guess you could say, some type of foreign influence on what American people see on their For You page and things of that nature. So TikTok says that is absolutely false, and that this would just be this is just Congress and the American government trying to take away Americans' First Amendment rights. And I want to go over just the entire TikTok argument, because in their briefing and kind of their summary of their argument, the the District of they say that the District of Columbia Circuit Court has already ruled against this argument from TikTok, I should say, which TikTok claims was wrong, and that the government inaccurately argues that this was nothing to do with the First Amendment. So that is what the government is arguing, and we'll get into what the Attorney General of the Department of Justice, their argument says in just a moment. And something I noted in this case is that they do not argue that they have control of the algorithm or the recommendation engine. Their parent company, ByteDance, does. And that is what the government and the Department of Justice has said all along in their briefs filed to the Supreme Court, saying that that this is the entire reason why this app could possibly have some type of foreign influence on the American people and be taking their information that is given on the app. There was even a hearing held in Congress all about this. So again, something you have to point out and something that's likely to be asked by the justices is, why does TikTok not say that they have control? Because at the end of the day, TikTok is an American-owned company. ByteDance is not, and that is what the government says has control of the recommendation engine and the algorithm. But TikTok refutes that the government's argument that the app lacks First Amendment rights because it doesn't control its algorithm and recommendation engine, while the governmental argument says ByteDance's control of the algorithm and recommended search engine is a threat to national security. They say it gives sensitive information on 170 million Americans to foreign adversaries, which in kind of in the name here, the Republic of China, who has where ByteDance is owned at there. And the government says TikTok's First Amendment argument doesn't apply, as ByteDance is a foreign entity and lacks First Amendment right protections. Now, something you must note here, I'm just trying to go over this really quickly before we see the Supreme Court get into session, and let me get ready for that to begin, which should occur any moment now. Oh, I apologize, wrong thing there. Stand by with me because we're standing by for the Supreme Court to begin oral arguments, and we will listen in as soon as that happens. Top of the hour, 9 a.m., and those oral arguments should begin at any moment now. So stand by with me here so I can quickly fix something. We'll go over a little bit of the argument at the beginning here because we know they discuss other things here. Stand by with me because you should hear oral arguments begin here any moment. Okay, I'll continue going over the argument while we have it, and let me while we stand by here and await for oral arguments in the Supreme Court to begin live here, we are going to talk a little more about the case and the government's argument, because I have one video I'd like to play. I don't know if I can play it to its full extent here, as it is. Oral arguments are expected to begin in the court any moment now. Okay, we are going to stand by and listen in here for just a moment, as you're expected to hear arguments beginning in the Supreme court. We will stand by for that to begin. I want to keep going over, again, as I was just saying, this argument that is being made. And I want to mention here, Kevin O'Leary, the member of Shark Tank, he says that he is interested in buying the application and is in communication with TikTok in buying it, but they have not made a deal. And he mentions that TikTok does not want to sell its algorithm, which has been the biggest deal in all of this. In American companies trying to buy this, because TikTok is famously known for their algorithm. And Shark Tank cast member Kevin O'Leary says that he's interested and would, in fact, buy the application. So again, what you're seeing there on the other side of your screen there, as we stand by for that argument to begin in this case. We are waiting any moment for it to begin. The court has convened, though. The court has, in fact, convened, and we are standing by to hear some type of audio in this. So when we get that, we'll listen into it, but I want to play this video right now of Shark Tanker Kevin O'Leary nearly 8 months ago talking about buying the application on Yahoo Finance.
7.2 million small businesses in America generating $11 billion of revenue. Yeah. That's why. What really matters is to understand who controls the deal. There's only one individual that matters right now. It's the supreme leader of China. Everybody else is irrelevant. Now, you have to ask yourself, what are his motivations? He could shut it down. He could say, look, we're just not going to sell it. Here's why he won't do that. There are many investors in ByteDance that are international and U.S. domestic investors. That whole value proposition goes to zero. So his cost of capital for financing China growth in the future is going to be much higher if he starts wiping out businesses that foreign investors invested in. So he's not going to do that. Then he has to decide, what do I want to sell? He doesn't want to sell the algorithm. That's widely known, so you're going to have to rewrite it. But we have precedent for this. When Skype was sold to Microsoft, they rewrote it in a matter of 6 months. We're going to have to do the same thing. But here's the real challenge. How do you keep those 7 million businesses that are generating all of that revenue on board during the choppy period of rewriting this algo?
Shark Tank member Kevin O'Leary there saying that there is precedent, the factor that this application is not wanting to sell its algorithm. He says there is precedent, talking about Microsoft buying Skype and its algorithm. Again, saying there is precedent for that to be happening. All he would have to do is rewrite it. We are standing by for oral arguments to begin here in the Supreme Court. Any moment now, they should begin. I want to keep talking about this because Trump has filed a brief in this case asking the Supreme Court to block the law, and when Trump takes office, after the said ban will happen on January 19th, on January 20th, he says that he will save the application. He's going to attempt to, but you have to consider something I was asking myself is, how's he going to save the application when the Republican lawmakers are essentially the ones that led this bill to ban the application? So he's going to have to get a lot of Republican lawmakers on hand with what he wants to do with this app. And we are trying to get a feed here. I apologize, I'm moving some things around so we can end the glitching. Trump is going to have to get a lot of Republican lawmakers on hand with him in order to get some type of block on the bill passed. And what we could, and another question I was asking before I saw the brief from the former president, I should say president-elect now, is could you see kind of SCOTUS hold an opinion, and then when Trump goes in office on January 20th, he gets Republican lawmakers to repeal this law in a quick fashion, and then the Supreme Court releases an opinion saying now there's no merit to be arguing on because the law is no longer a thing, saying that TikTok must be sold to a foreign entity, not a foreign entity, I should say, by January 19th. But again, as I was saying, Trump had asked the Supreme Court in a brief to block this and for there to be some type of way that he could save the law. We are going to take a quick 2-minute break here as we continue to stand by for the Supreme Court to begin oral arguments in this case. And a nice welcome back here in Brooklyn, Arkansas, as we stand by to hear oral arguments from the Supreme Court. We have not heard, they have not yet convened yet. We are standing by for that. As soon as they do, you will hear that audio on your screen. But again, not yet convening, and we are continuing to stand by for that to begin here.
Mr. Chief Justice, and may it please the court. Under the Act, most popular speech platforms will shut down in 9 days. That shouldn't happen.
Okay, you are seeing there now audio coming in there. Let's listen in now to the Supreme Court.
The Act requires it to go dark unless ByteDance executes a qualified divestiture. Whether you call that a ban or a divestiture, one thing is clear. It's a burden on TikTok's speech, so the First Amendment applies. Second, the Act is content-based from beginning to end. It applies only to social media platforms that have user-generated content, except for business, product, and travel reviews. Within that content-based universe, it singles out a single speaker for uniquely harsh treatment. And it does so because the government fears that China could, in the future, indirectly pressure TikTok to disseminate foreign misinformation and propaganda. Finally, the Act can't satisfy any standard of scrutiny. The government has no valid interest in preventing foreign propaganda. And its fallback, that it seeks merely to prevent covertness, makes no sense, since that could be addressed with a risk disclosure. The government's real target, rather, is the speech itself. It's fear that Americans, even if fully informed, could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the president-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok speech here?
TikTok, Your Honor, uses an algorithm that in its view reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quotes, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and—
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So sure.
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all. And if you do that, you're going to be severely punished for doing that.
All right, we can go on to the effectiveness of the remedy. But the point is, I believe that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States,
Sure.
Going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
Keep going.
You can't really take those cases and extend them to an area where there is no scarcity, like the World Wide Web, because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights. And I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true. The court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that, all right? What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
because there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself.
All right, let's say that's not a
United States company.
Let's say this is not a complete answer to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment. And if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok US has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What's the fact? What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice for the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated, as a U.S. company, does have its own set of First Amendment rights.
Okay. And then another fact question. Before the DC Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
I just want to understand what's before us. Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos.
I got it.
We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows first what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
Removed or
reports.
restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things that where I don't know what the accusation
I have other
is.
questions about the secret evidence in this case, but we'll get to that later.
Yes,
Thank you.
Your
Mr.
Honor.
Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. I would say it's, the algorithm is a lot of things. The algorithm has built within it. It's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says, or say, you know, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
well,
any?
We absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level
Yes,
of
Your Honor.
the application. I'm trying to, I mean, let's say that I agree with you, the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. You know, there's a disproportionate burden. Let's say
Right.
that I agree with you about that. No one is preventing you. I mean, you're seeking access to a particular source code, engineering, the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. I mean, the government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the law itself is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it going, is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. If I was unclear on that, Your Honor, I apologize. That
Okay,
is
because I
absolutely
think
the core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company. And you started off with Justice Alito saying, well, we would be making a different argument. And of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. And I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition
Well, I
that's
realize
imposed
that
by law.
it definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business, product, and travel reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. Let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that as affecting TikTok, as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok through ByteDance to TikTok to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. Maybe ByteDance will figure out a way to put this on open source, and then TikTok will be able to use the algorithm.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights. To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case. Yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say that there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what, where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company should be, others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like ACARA. And what ACARA says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict
scrutiny. So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok, TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas, Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application?
All right, I'm going to
from
break
gathering.
into this argument. I must apologize because I know how interesting it has become, but we are learning some breaking news that has just come in within the last few moments. We will join back in with that in just a moment, but we have audio inside that hearing that happened just moments ago where Donald Trump was sentenced with let me go back to my notes here to get the exact charge. Sorry, I was just taking notes there before. He was actually, next page, I apologize, a lot of notes going on here. He was sentenced with an unconditional discharge. I apologize for breaking into that, but we do have the moment that this all goes down. I'm going to go. So we now have audio into it. We will go back to that Supreme Court, listening into that TikTok argument there. I apologize for that. We'll go back listening into that in just a moment. I just want to play this audio in full. This was just moments ago inside that courtroom. Let's listen in here as you take a look at that iDrive Arkansas traffic camera there on the left side of your screen. Again, just in audio from the Supreme Court. Not the Supreme Court, I apologize, but rather from the New York court where Donald Trump has just been sentenced with an unconditional discharge, I should say. We have audio now. Let's stand by here with me because let's
4 counts of falsifying business.
Let's listen in.
There's a range of authorized sentencing options for as much as one.
So I'm going to go back here because I want to break down what is occurring here.
Thank you, Judge.
What essentially is occurring as they were reading that case is Judge Juan Merchan is handing them the briefs with the charges and everything like that. So
Sure.
listen in.
I don't think there's anything that we need to put on the record about it.
Okay, thank you. Let's impose sentence, please.
Donald Trump, you're before the court for sentence following your conviction by trial to 34 counts of falsifying business records in the first degree. Before being sentenced, the court will allow you, your attorney, and the assistant district attorney an opportunity to address the court with any matters relevant to sentencing. For the people,
Thank you. Judge, where's the preferred place for me to stand?
Wherever you feel comfortable.
Okay. The defendant in this case, as you know, stands convicted of 34 counts of falsifying business records in the first degree, all Class E felonies. Each carries a range of authorized sentencing options for as much as 1 1/3 to 4 years in state prison to a variety.
So I want to pause this and break down what is going inside that New York court. This is the audio just now for President-elect President-elect Trump's New York sentencing hearing. What's happening now is you are hearing Joshua Steinglass arguing for the district attorney's office. Essentially what he is expected to say here in the next few seconds is that there are a number of sentencing options, but that they believe he should be charged with that unconditional discharge. So let's listen back in here for just a moment.
Of non-incarceratory sentences. In this court's January 3rd decision on the defendant's Clayton motion, Your Honor indicated an inclination to impose an unconditional discharge. Under all the circumstances of this case, its unique posture and the defendant's status as president-elect, the people recommend a sentence of an unconditional discharge.
And you heard it there, exactly what I was talking about. And we are now, in just a moment here, as soon as Joshua Steinglass steps down, going to hear from, I want to say, we're going to hear from Todd Blanche, if I'm correct. So let's listen back in.
In finding the defendant guilty in this case, the jury necessarily found unanimously that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means. Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict. I'm certainly not going to rehash that now. In last week's decision on January 3rd, this court referred to the gravamen of the defendant's conduct, his criminal conduct in this case, as constituting, quote, premeditated and continuous deception. The verdict was delivered by a jury that was carefully chosen using an extensive questionnaire based on suggestions from both parties and after thorough questioning of the prospective jurors by both sides. The verdict in this case was unanimous and decisive, and it must be respected. As this court has observed, quote, the sanctity of a jury verdict and the deference that must be accorded to it is a bedrock principle in our nation's jurisprudence. The defendant's conduct before, during, and after this trial also merits consideration. Instead of preserving, protecting, and defending our constitutionally established system of criminal justice, the defendant, the once and future President of the United States, has engaged in a coordinated campaign to undermine its legitimacy. Far from expressing any kind of remorse for his criminal conduct, the defendant has purposefully bred disdain for our judicial institutions and the rule of law. And he's done this to serve his own ends and to encourage others to reject the jury verdict that he finds so distasteful. He has characterized these proceedings as corrupt, rigged, a witch hunt, or a sham too many times to tabulate. The defendant's rhetoric has only ratcheted up since this court's rulings on his motions to dismiss. He has been unrelenting in his unsubstantiated attacks upon this court and its family, individual prosecutors and their families, the witnesses, the grand jury, the trial jury, and the justice system as a whole. The defendant has not only been held in contempt by other jurists in other matters, but this court alone found the defendant in contempt for 10 distinct violations of the order restricting extrajudicial speech. In his legal filings, the defendant has used dangerous rhetoric in leveling accusations of intentionally unlawful and unconstitutional conduct on the part of this court and the prosecution. As this court has noted, the defendant's conduct, quote, constitutes a direct attack on the rule of law itself. Moreover, the defendant has publicly threatened to retaliate against the prosecutors who have sought to hold him accountable in this and other matters, and the courts who have endeavored to fairly and faithfully adjudicate these matters. Such threats are designed to have a chilling effect, to intimidate those who have the responsibility to enforce our laws, in the hopes that they will ignore the defendant's transgressions because they fear that he is simply too powerful to be subjected to the same rule of law as the rest of us. In his 2024 end-of-year report, United States Supreme Court Chief Justice Roberts warned of the dangers of such conduct. Quote, public officials too regret.
So essentially what you're hearing Joshua Steinglass do there is say, we want this to happen. We're not going to rehash these 34 felony counts. Rather say that he was in fact found guilty, and we want this, I should say, stand by here for my papers here. We want this to be an unconditional discharge. And that is what Joshua Steinglass is asking. And you're seeing there on your screen now a live look at the iDrive Arkansas camera there. We've been just watching it because we are following this breaking winter weather news, you could say, and are watching it as it all goes down. I want to listen back in here for just a moment.
Have engaged in recent attempts to intimidate judges. For example, suggesting political bias in the judge's adverse rulings without credible basis for such allegations, end quote. Chief Justice Robert continued, quote, attempts to intimidate judges for their rulings are inappropriate and should be vigorously opposed. Public officials certainly have a right to criticize the work of the judiciary, but they should be mindful that intemperance in their statements when it comes to judges may prompt dangerous reactions by others. Chief Justice Roberts also spoke of the dangers of disinformation, which are, quote, magnified by social media, which provides a ready channel to instantly spread rumor and false information. Put simply, this defendant has caused enduring damage to public perception of the criminal justice system and has placed officers of the court in harm's way.
And I want to note here what you are listening to for anyone just joining us. I know you can't see exactly what we're listening to, and that thumbnail says that we are listening to the TikTok argument. That is, right now, there has been some breaking news. Today was the day that President-elect Donald Trump was sentenced. Judge Juan Merchan presiding over that case where Donald Trump was convicted and found guilty of 34 felony counts of falsifying business records in the first degree. Now what you are listening to is the audio just released. And you are listening to Joshua Steinglass, who is arguing for the District Attorney's Office of Manhattan, say that Donald Trump should be charged with the unconditional discharge, which is ultimately what he was charged as. Now, on the left side of your screen, you are looking at live at an iDrive Arkansas camera there on the interstate as we see some snowy conditions, still snowing right here in Brooklyn and right over there. As we continue to follow this winter weather, we're also following the news, those California wildfires, and we'll keep you updated on any new information that comes about. But again, we are not listening to the TikTok arguments for just a brief moment. We'll listen back in just a moment, but the audio has been released from the President-elect Donald Trump's New York City sentencing hearing. Him and his attorney, Todd Blanchard, appeared virtually today in court, but audio has just now been released. The first time that we are going to hear Judge Juan Merchan, the judge presiding over this case, his actual voice publicly, because we've heard Todd Blanchard's voice. We've obviously heard President-elect Trump's. We've heard Joshua Steinglass's voice before, and everyone else's voice in different press conferences and different things like that. But I want to keep listening in as we still have a bit to go, because we're going to hear from Todd Blanchard, and then we will hear from the judge. I do believe so.
In the probation report, which we just received this morning, the author, having interviewed the defendant, noted that the defendant sees himself as above the law and won't accept responsibility for his actions. And that's certainly consistent with everything else that we've seen. Now, in a typical case, both the offense conduct and these other exacerbating factors would impact the appropriate sentence. But in this case, we must be respectful of the office of the presidency and mindful of the fact that the defendant will be inaugurated as president in 10 days.
That is something key you have to know. What you just heard from Joshua Steinglass here, as we've heard his argument, saying that you must know that even though he has asked the Supreme Court which to get rid of his sentencing today and block it, essentially, which the Supreme Court with two Republican-appointed judges saying no to that, and Supreme Court Justice Clarence Thomas and saying that, yes, this should be blocked, but we saw it not blocked late yesterday night. I'm sorry if I'm not making any sense, forgive me. But Donald Trump asked the Supreme Court to hold and block this sentencing from occurring. Two Republican-appointed justices signed with the Democratic-appointed justices saying that no, it will go on after these lawyers argued that why should it be blocked? We're at the end of this road. And then Judge Juan Merchan saying that it was very likely that he would be charged with this so-called, with an unconditional discharge, which is essentially just a nothing charge. It means literally nothing's going to happen. And we're going to hear Judge Juan Merchan explain why he was charged with this. But what you heard there from Steinglass saying that even though he asked the Supreme Court to do something like this and tried to go against it, well, allegedly, I want to say that's not my own opinion, that's just a kind of summarizing here, paraphrasing what Joshua Steinglass said, not of my own opinion, but that even though he tried to act as if he was above the law, that we understand that he is fixing a precedent and will be inaugurated in just 10 days, and that he should be charged with this so-called unconditional discharge. So listen back into Joshua Steinglass.
Any undischarged portion of a sentence has the potential to interfere with the defendant's performance of the duties of his office. As a practical matter, the most sensible sentence prior to his inauguration is an unconditional discharge. The court has expressed an inclination to do exactly that because, in the court's words, quote, the most viable solution to ensure finality and allow defendant to pursue his appellate options, is to proceed to sentence. Now, as you know, in New York, a conditional discharge is authorized by penal law, quote, if the court, having regard to the nature and circumstances of the offense, public interest nor the ends of justice would be served by a sentence of imprisonment, and that probation supervision is not appropriate. An unconditional discharge is authorized if a conditional discharge is authorized and, quote, if the court is of the opinion that no proper purpose would be served by imposing any condition upon the defendant's release. Because these crimes are felonies, the court must set forth in the record the reasons for its action. The American public has the right to a presidency unencumbered by pending court proceedings or ongoing sentence-related obligations. But imposing this sentence ensures that finality. Sentencing the defendant permits this court to enter judgment, to cement the defendant's status as a convicted felon while he pursues whatever appeals he intends to pursue. And it gives full effect and respect to the jury's verdict while preserving the defendant's ability to govern. The people therefore recommend that this court impose a sentence of an unconditional discharge. Thank you.
Thank you. Counsel.
Thank you, Your Honor. I very much disagree with much of what the government just said about this case, about the legitimacy of what happened in this courtroom during the trial, and about President Trump's conduct fighting this case from before it was indicted, to while it was indicted, to the jury's verdict, and even to this day. What the government just said presupposes something that we disagree with very much, which was that this was an appropriate case to be brought. It was not. This case, without a doubt, knowing everything we know about the timing of the investigation, the fact that multiple prosecutors looked at the fact of this case, including prosecutors within the district attorney's office in New York County, and made a decision not to bring charges. As the court knows, shortly after President Trump announced his intention to run for re-election, this case was started for what amounted to a third time, which brings us ultimately to where we are today. A lot of what the government just said presupposes that this case is legally appropriate and that the charges that were brought by the people were consistent with the laws of New York. Again, we very much disagree with that, and as everybody has been noted, because it's true, we certainly intend on appealing that. And it's not, by the way, just counsel and President Trump that feels that way. There's many, many, many legal experts that share the same views that I just said, which is that legally this case should not have been brought, both based on the facts that were established at trial and also on the legal basis for which they were brought. But it's also not just the legal experts, not just counsel, and not just President Trump, but the majority of the American people also agree that this case should not have been brought. I mean, the interesting thing about the fact that there was a trial for the first time in our history, a criminal trial during an election season, is that the American voters got a chance to see and decide for themselves whether this is the kind of case that should have been brought. And they decided. And that's why in 10 days, President Trump is going to assume the office of the President of the United States. And certainly we're here for the court to sentence President Trump to an unconditional discharge. And for that, it's a very sad day. It's a sad day for President Trump and his family and friends. But it's also, in counsel's view, a sad day for this country, because this was a case, without a doubt, that was brought by a district attorney who promised that he would go after President Trump if elected, and felt like he had to go through with that promise. And so that's sad. And I hope, and I know that President Trump shares this view, that this will never happen again in this country. And so we certainly understand where we are today. We very much intend on pursuing an appeal of this verdict and what happened during this investigation. And we certainly believe that the only appropriate sentence, if one's to be imposed at all, which we very much believe it shouldn't be, and that the case should be dismissed, is a sentence of an unconditional discharge. Thank you.
Thank you. Would your client like to be heard?
Yes, thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This is a case that Alvin Bragg did not want to bring. He thought it was.
And I want to note that you are now hearing, you just heard from Todd Blanche arguing that they are going to appeal this, that they believe these charges were, I don't want to say rigged, but false, not true. And now you're hearing Donald Trump talk. Let's continue listening in here.
From what I read and from what I hear, that inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney. And that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent. Part of the records that we're talking about, they're saying, I just noticed that where he said I was falsifying business records. Well, the falsification of business records, as they said, was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me, they were put down by accountants. I didn't call them construction, concrete work. I didn't call them electrical work. I didn't call them anything. They called a legal fee or a legal expense. And for this, I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television, that are making their views felt and highly respected people, have said, everyone, virtually everyone that I know of, I haven't seen any to the contrary, not one. And none, these people are not exactly friends of mine, to put it mildly. But they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that. Paul Ingrassia, Alan Dershowitz, they all said this is not a case that should be brought. It's not, think about it, legal expenses are down as legal expenses, and
So now what you are hearing is Trump mention what he has done multiple times in this courtroom, but also just in public, mentioning these number of legal analysts that say that they're only bringing this as a political motivation, that it's all because the District Attorney, Manhattan District Attorney, I should clarify, Alvin Bragg is only bringing this because he dislikes Trump and he doesn't agree with him politically. Let's listen back in, though.
Get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work. And the people of our country got to see this firsthand because they watched the case in your courtroom. They got to see this firsthand, and then they voted, and I won and got the largest number of votes by far of any Republican candidate in history, and won, as you know, all 7 swing states, won conclusively all 7 swing states, and won the popular vote by millions and millions of votes. And they've been watching your trial, so they understood it. I wasn't allowed to use the lawyer-client privilege or the reliance on counsel. I had a lawyer that made this deal, and he admitted that. And he was also a totally discredited person. We weren't allowed to use the information from the Southern District that totally discredited him. It wasn't allowed to be put in. And that was terrible, unbelievable. And this is a man who's got no standing. He's been disbarred on other matters, unrelated. And he was allowed to talk as though he were George Washington. But he's not George Washington. He shouldn't have been allowed. The Southern District did a book of approximately 28 pages where I've never seen anything like it. They excoriated him. You wouldn't let it be put into evidence. So he was able to testify as a witness, and I think it's a disgrace to the system. I was under a gag order. I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. I guess I'm still under, so probably I won't do it now. I assume I'm still under a gag order. But the fact is that I'm totally innocent. I did nothing wrong. They talked about business records, and the business records were extremely accurately counted. I had nothing to do with them. That was done by an accountant or bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked. And with all that's happening in our country today, with a city that's burning to the ground, one of our largest, most important cities burning to the ground, with wars that are uncontrollably going on, with all of the problems of inflation and attacks on countries and all of the horrible things that are going on, I got indicted over calling a legal expense a legal expense. It was called a legal expense. I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. It's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's going on. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. And I'd just like to explain that I was treated very, very unfairly. And I thank you very much.
Thank you, Mr. Trump. Mr. Trump, you appear before this court today to conclude this criminal proceeding by the imposition of sentence. Although I have taken the unusual step of informing you in advance of my inclinations, before imposing sentence, I believe it is important for you, as well as those observing these proceedings, to understand my reasoning for the sentence I am about to impose. The imposition of sentence is one of the most difficult and significant decisions that any criminal court judge is called upon to make.
Okay, Trump stopped his speaking there, and now I believe we're hearing from Judge Juan Merchan, who is saying that it was hard to sentence someone who is going into office in 10 days. I want to continue listening in here, though.
Our legislature sets the parameters for an authorized sentence, but it is a judge that must decide what constitutes a just conclusion to a verdict of guilty. A court is vested with broad discretion in determining what sources or evidence it may consider to arrive at an appropriate sentence. In doing so, the court must consider the facts of the case along with any aggravating or mitigating circumstances. In my time on the bench, I've been called upon to grapple with this weighty responsibility for countless defendants who have been found guilty after trial for an assortment of offenses, ranging from nonviolent Class E felonies to the most heinous of crimes, including homicides, sex trafficking, and child sexual abuse. The task is always difficult and deserving of careful consideration, whether the sentence be an unconditional discharge or incarceration of 25 years to life. However, never before has this court been presented with such a unique and remarkable set of circumstances. Indeed, it can be viewed fairly that this has been a truly extraordinary case. There was unprecedented media attention, public interest, and heightened security involving various agencies. And yet, the trial was a bit of a paradox because once the courtroom doors were closed, the trial itself was no more special, unique, or extraordinary than the other 32 criminal trials that took place in this courthouse at the same exact time. Jury selection was conducted, the same rules of evidence were followed, opening statements were made, witnesses called and cross-examined, evidence presented, summations delivered. The same burden of proof was applied, and a jury made up of ordinary citizens delivered a verdict. And it was all conducted pursuant to the rules of procedure and guided by the law. Of course, part of what made it feel somewhat ordinary was the outstanding work, preparation, and professionalism of the clerks, court officers, court reporters, security personnel, and the entire staff of this building who did their jobs as they would with any other criminal trial. So while one can argue that the trial itself was in many respects somewhat ordinary, the same cannot be said about the circumstances surrounding this sentencing. And that is because of the office you once occupied and which you will soon occupy again. To be sure, it is the legal protections afforded to the office of the President of the United States that are extraordinary, not the occupant of the office. The legal protections, especially within the context of a criminal prosecution, afforded to the office of the President have been laid out by our founders, the Constitution, and most recently interpreted by the United States Supreme Court in the matter of Trump versus the United States, which was decided on July 1st, 2024. As with every other defendant in your position, it is my obligation to consider any and all aggravating and mitigating factors to inform my decision. Some of those aggravating factors have already been articulated in my Sandoval ruling at the start of this trial and by my recent written decisions on December 16th and January 3rd. Thus, they need not be repeated at this time. However, the considerable, indeed, extraordinary legal protections afforded by the office of the Chief Executive is a factor that overrides all others. To be clear, the protections afforded the office of the President are not a mitigating factor. They do not reduce the seriousness of the crime or justify its commission in any way. The protections are, however, a legal mandate, which pursuant to the rule of law, this court must respect and follow. However, despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict. It is clear from legal precedent, which until July 1st was scarce, that Donald Trump, the ordinary citizen, Donald Trump, the criminal defendant, would not be entitled to such considerable protections. I'm referring to protections that extend well beyond those afforded the average defendant who winds their way through the criminal justice system each day. No, ordinary citizens do not receive those legal protections. It is the office of the president that bestows those far-reaching protections to the office holder. And it was the citizenry of this nation that recently decided that you should once again receive the benefits of those protections, which include, among other things, the Supremacy Clause and presidential immunity. It is through that lens and that reality that this court must determine a lawful sentence. After careful analysis, in obedience to governing mandates, and pursuant to the rule of law, this court has determined that the only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge, which the New York State Legislature has determined is a lawful and permissible sentence for the crime of falsifying business records in the first degree. Therefore, at this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office. Thank you. Have you given your client his written notice of right to appeal?
We will, yeah.
Thank you.
So you have just heard it there. That was, and I apologize to our viewers here for that, Juan Merchan charging Donald Trump with an unconditional discharge. I'm also learning, as we are on the air, we are receiving an update from officials on that wildfire in those wildfires. We are receiving an update. We are going to listen in here for just a moment, if we can. I stand by here because I do have to get everything ready. So let's go back out live here to Brooklyn News headquarters here in Brooklyn, Arkansas. Sorry, I was just fixing something there. Back here in Brooklyn News headquarters. So again, we were just now listening to the court proceedings that just occurred, the hearing where Donald Trump was sentenced with a stand by here. Let me get my notes back out. I keep forgetting what he's being charged with. Unconditional discharge. I'll remember it. I always think discharge and then I never think the rest. So, Mayor, officials from Los Angeles are delivering an update. We are going to go to that, I do believe so, in just a moment. Stand by here. I just have to get okay, we're going to get an update that officials are just delivering just moments ago in Los Angeles.
States and Eaton fire areas in all mandatory evacuation zones. That will be in effect. It was in effect last night, and it's going to be in effect tonight at 6.
Okay, I cannot be the only one wondering what has just occurred and why we just like it sped through and we randomly went to Attorney General Merrick Garland, delivering some type of conference. I do not think it was on BN's side of things. I think it was on where we're getting this feed from, and that we have it back now. Let's listen back in here.
Them to leave, and I want them to feel confident that we are doing everything we can to secure that. This curfew will be strictly enforced and is being taken to enhance public safety, protect property, and prevent any burglaries or looting in the area that the residents have evacuated. The only people that will be allowed in these areas are disaster workers. Okay, I just want to make that clear because we have other people trying to get in there. And by the way, media partners who have legitimate media credentials, yes, you may enter those areas unless it's very, very unsafe and somebody tells you not to for that reason. Again, just specifically, anyone found in violation of this curfew will be subject to arrest for a misdemeanor offense under LA County Code Section 2.68320, and conviction may result in a fine up to $1,000 or jail time. And I'm telling you right now, I know people talk about no bail, and I've given direction that if somebody's caught doing this, they are not going to get cited and released. They're going to get booked. We are not screwing around with this. We don't want anyone taking advantage of our residents that have already been victimized. The National Guard deployment. As many of you are aware, we asked for the National Guard. I'm very thankful to Governor Newsom and the State Office of Emergency Services that fulfilled that request. As of last night, we've had National Guardsmen assisting us. They arrived last night and deployed to the Eaton Fire area, and we're assisting with road closures and critical infrastructure protection. As additional Guard personnel arrive, and they will be in the next 12 to 24 hours, the Sheriff's Department will strategically coordinate their deployment with other partners, such as the Los Angeles Police Department, Pasadena Police Department, Santa Monica Police Department.
That is, I don't want to misname anyone, but I believe the Los Angeles County Sheriff there delivering a briefing. We will monitor that, and if we need to listen back into it, we absolutely can and will do that. But that feed there just from moments ago when we saw that briefing being held, we are going to, I believe the TikTok hearing is still ongoing. It's going to take me just a moment to get that feed pulled up, though. That was the Los Angeles County Sheriff, though. We will monitor that as the day does in fact go on. I'm Jackson Mitchell. I want to recap what has all occurred. We've been live now for almost 2 hours, and there has been a lot that has occurred since I have been on the air. At first we're listening to Supreme Court arguments. We first were monitoring, we've been monitoring a number of events. You just saw that was an update from the California wildfires. We were just listening into Trump's audio there and him being sentenced, and then we went to, and then we're also monitoring the snow right outside, right behind this wall. Actually, there's snow, and outside that window right over there. We've been monitoring that throughout the last 1 hour, 42 minutes now. So much to talk about. We've really, throughout this entire time, we've been looking at this Arkansas Department of Transportation camera, which has shown the snow on the side of the roads. Of course, a number of cars have in fact been through a lot of these areas, which has led to this happening. I want to see if we still have Supreme Court arguments going on. I don't exactly know just yet. There's a look back at that. We have it. There we go. Boom.
To our attention.
A look back at that Arkansas Department of Transportation camera, and that's exactly what I was just talking about. We saw there, I apologize. That is going to mess with it, but I do in fact apologize for that. I have to do that because I have so many different windows open. This is the laptop controlling everything essentially, and then right in front of me, while I'm always looking down, is because right here is where I'm controlling what you see, and right here is where I'm controlling all our video feeds and things of that nature. So that is a look at that Arkansas Department of Transportation camera that I was just talking about a moment ago, where we have been watching pretty much this entire time, and it's really just shown snowy roads. Now, I will say, I think it's honestly gotten a little bit better as the day has gone on. It's gotten, I wouldn't say a lot better, just a little bit, showing these snowy roads, because enough cars have driven through it, and you can actually see the divider there. I believe this is I-55. Forgive me if I am wrong. Sorry, getting the Supreme Court arguments pulled up here so we can listen back in there, because we've been monitoring that this entire time. But and throughout these arguments, they have talked about a number of things. I think now what we are going to be hearing is the prosecution argument. It's going to take me just a moment to get these pulled back up. I apologize. But again, what I was saying is I believe we might be hearing the prosecution argument talking about this, just because of we were hearing before we left you and went to this breaking news, because we had just had audio before we left that. Excuse me, we were hearing from, pardon me, we were hearing from the defense, Noel Francisco, not the defense, maybe the defense. Okay, Noel Francisco was the lawyer for TikTok and ByteDance, was speaking. We now have, we now can go back at live, where, we are now seeing the attorney for TikTok content creator Brian Fireball speaking now, and so we're still hearing a little bit from what I would say the defense here. So let's listen back in. Can we hear? Give me just a moment. Let's listen back in now to Supreme Court arguments.
Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember, where you're not even creating speech, you're just listening. That was speech from China.
Again, I apologize for muting that again, but that is Jerry Fisher there, talking with Justice Elena Kagan, and let's go back live out there.
View the exact same First Amendment rights as your users do. In other words, it's irrelevant that the foreign corporation doesn't have First Amendment rights.
I don't think it's irrelevant, because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto, written by Karl Marx, has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well, sorry. Go ahead.
No, I'm fine.
No. I'm good. Okay. So I want to press you a little bit on the distinction, because in Lamont, the prohibition worked directly on the American. Like, you have to specifically request this information that comes. This is working kind of as Justice Kagan's questions were pressing you. This is working on ByteDance. It's not saying to your creators, you can't post on ByteDance. That's indirectly going to happen if ByteDance chooses itself not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont's actually a very important case I'm sure you all recognize here. It's important to look not just at the court's opinion, but look at the briefing in that case. The government itself never came in and argued there's no right to receive this information. That's the sort of greater argument.
I want to apologize. I don't mean to be just continually breaking in here, but I'm changing something around to possibly get a better feed for you all. Just stand by with me now. We should have a better feed that we're actually able to play for you all. And there we go. We're going to lose that RDOT feed for just a moment. But this will allow for a more direct feed with less. I don't know if it's glitching for you guys, but I know it is for me. So I want that to end. So this may be a little bit better. Let's turn it all the way up.
That is a lot. That's only a small part of the argument I'm making on behalf of the creators. You know, I don't mean to diminish Mr. Francisco's arguments on behalf of the company and ByteDance, but the core speech in front of you in this case are the videos and other forms of communication that people like my clients are posting by the millions every day on this platform to share with other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I mean, I don't think we should. But
was it possible for you to win and him to lose? I mean,
well, let me put it this way. If you were to conclude that something about the corporate ownership structure, and I think there was some conversation about this earlier, impeded Mr. Francisco from being able to assert full-throated First Amendment rights in this case, I would step in and say, well, certainly we can do that and get you to the strict scrutiny. And then the arguments pretty much line up. Then you're in a question of, can the government satisfy strict scrutiny? And I think, Mr. Chief Justice, you asked about, do we have cases for this and that? I think that the idea is, yes, we have cases that say, once you're in strict scrutiny, that regulating the content because you don't think it's going to be pro-American enough or it's going to be too pro-foreign interest is just verboten under the First Amendment. That's the history and tradition. And Justice Kavanaugh, when you asked about the broadcast cases, they're grounded not just in scarcity, but they're grounded in scarcity in a particular way. It has to do with the absolute need Congress has for licensing in a world of scarce resources. And so that's the very small carve out that even in Turner, the court wouldn't extend to cable television that exists for broadcast licensing. And if you look on the 200 plus years of our country for any other example of foreign ownership of media being regulated by Congress, let alone being permitted in the case law, you are not going to find it. And I think the reason why is because everybody has understood that if you're not in a world of scarcity where licensing is impossible, you cannot give the government, and in this more extreme example, the president himself, unbridled discretion to choose who is a proper owner of a speech platform in this country, because it is so hand in hand with viewpoint. As I said earlier, any number of owners of big media enterprises, whether they be Americans or foreign citizens, could be accused of having a particular viewpoint, but speakers who engage in those platforms have choices they can make. And so, on behalf of our creator clients, we find it not at all satisfactory to be told, well, look, just go post somewhere else. It's not enough to tell a writer, well, you can't publish an op-ed Wall Street Journal because you can publish it in the New York Times instead. Just like here to say, you can publish it on Instagram or some other platform, not just TikTok. TikTok has a distinct editorial and publicational perspective, and it particularly benefits people like my clients who are not famous people. They're not actors from Hollywood who have a lot of people following them. They're ordinary American citizens whose content that they create on the platform gets privileged by way of the quality of that content. And that's what's so powerful about the platform. So whether you're an ordinary American citizen or, I might add, whether you're a presidential candidate in our last election, if you want to reach new and different audiences, TikTok is the place people go.
This may not make any difference for constitutional purposes, but just out of curiosity, I'd like you to explain what the practical consequences would likely be for your clients if TikTok went dark, as Mr. Francisco put it. There, I assume, is a great demand for what TikTok provides. And if TikTok was no longer there to provide what your clients really want, is there a reason to doubt that some other social media company would not jump in and take advantage of this very lucrative market?
There are two reasons, Justice Alito. One is many of the declarations from my clients actually explain they've tried on other platforms to generate the kind of audience and engagement they've been able to on TikTok, and they've fallen dramatically.
Yeah, I know they haven't so far, and I'm just wondering whether this is like somebody's attachment to an old article of clothing. I mean, I really love this old shirt because I've been wearing this old shirt, but I could go out and buy something exactly like that. But no, I like the old shirt. Is that what we have here, or is there some reason to think that only ByteDance has this, the ByteDance has devised this magical algorithm that all of the geniuses at Meta and all of these other social media companies, they couldn't. No matter, they put their minds to it, they couldn't come up with this magical thing.
I think empirically, other companies have been trying for a few years to catch up with TikTok and replicate it and have been very unsuccessful. And so that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors. Imagine the floors of an office building being filled with a collection of editors. You could imagine a situation where that collection of genius that is on a particular floor cannot be replicated by another group of people. And that's kind of what you have here.
All right, I understand that.
Thank you, counsel. Justice Thomas? Anything further, Justice Alito?
Yeah, one other question. I'm intrigued by your Mount Healthy Hunter versus Underwood argument. I mean, maybe you're right, but Mount Healthy arose in an entirely different context where you're trying to get to an employer's motivation. Hunter versus Underwood involved an extreme situation where the court looked at the records of a state constitutional convention and came to the conclusion, apparently, that racism was the only motivation for what was done. But it does seem to me to be potentially quite unworkable and contrary to what we've generally said about legislative intent to apply the Mount Healthy framework to a congressional enactment. Do you recognize or do you acknowledge that that would be very difficult? Because when an act of Congress is passed, there could be more than 250 different motivations for the votes that were cast by the members.
Yeah, I totally understand that. And in Hunter, the court actually engaged with that problem to some degree. And what Hunter said is, to avoid that problem, we're going to look just to two things. One is the state's brief, which I'd say is the Solicitor General's brief by comparison here, and the text of the law. And here, that's the only thing I need to rely on to get you to the place that they wouldn't have enacted.
Well, it gets you to the place that this was part of what motivated Congress. But why does it get you home? Well, and particularly when there's a severability clause in this act.
It can't be only part of it. It has to be enough to sustain the entire act, or at least the parts that you wouldn't sever from the act. And so I think the reason why is because it's not just the content recommendation algorithm part that can be theoretically, I guess, severed out. It's also the covered company provisions, and it's just the whole approach of the statute that is based on content, not on data security.
All right, thank you.
So, okay.
Justice Sotomayor?
No, I'll save it for the SG.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Justice Jackson?
One quick question. You repeatedly say that from your perspective, the government's motivation is that the content might be too anti-American or too pro-China, et cetera. So that's why you think this is a content-based restriction. But I guess I'm curious if you would say the same thing if the government had articulated its rationale as saying, our motivation is to limit foreign interference in American social media platforms or discourse. Isn't that a different motivation from the standpoint of how we characterize this?
I agree, but then the question I would ask if the government said that, which I think kind of in the reply brief, maybe the government does say that, is that how on earth are you then serving a national security interest? If all you're doing is just saying, we don't like a foreign country rearranging cat and dance videos, it's hard to come in and make a national security argument. So the only way you get to national security, which is the government's own argument, is to look at the substance that's being rearranged and say, we don't like the way the substance is going to be rearranged and curated differently.
Thank you.
Thank you, counsel. General Prelager.
The Chinese government's control of TikTok poses a grave threat to national security. No one disputes that the PRC seeks to undermine U.S. interests by amassing
here at the end, I must apologize for kind of dipping back in to the Supreme Court arguments because we've had so much news, but we are very close to the 2-hour mark of our live coverage, and we've been bringing you that. We've been bringing you live coverage. You're listening to the Supreme Court, listening to press conferences, listening to the sentencing of President-elect Donald Trump. What we are going to do here, though, is take another pause from listening into this oral argument in the Supreme Court take a quick 2-minute break, and at the top of the hour, we'll recap everything you need to know. But we're also going to turn our coverage to this winter storm that's ongoing out the door. We will be right back here in just 2 minutes here on BN. We will be right back here in just 2 minutes right here on BN. I'm Jackson Mitchell. Our coverage continues at the top of our 2-hour mark. Moments away. And a nice welcome back to all of you out there. I'm Jackson Mitchell, joining you here in Brooklyn News headquarters here in Brooklyn, Arkansas. Apologies, changing just a few things here. Sorry, I've got to change just a. Sorry, before I go to break, I change all the things at the top, everything like that. But see, now I'm having to do it live. So this is a Brooklyn News special report. Thanks for joining me. We've now been live for about 2 hours, 10:48 a.m. We've been live since about 8:50, covering all of this. So much to cover, truly. And we came on the air originally to talk about this TikTok versus the Attorney General, and we listened into that argument for a large part of our live stream. But there's also been a number of other news events ongoing that we have listened into for the last little while, including Trump being sentenced. Trump being sentenced to an unconditional discharge, meaning it's essentially nothing, as he is President-elect Joshua Steinglass asked the attorney arguing for the prosecution, the Manhattan District Attorney's Office, saying that that's what they wanted, noting that while Donald Trump has, according to the prosecution, tried to kind of betray the facts in this case, that they are still asking for a honorary, unconditional discharge. We are coming to you also as California wildfires are ongoing. They provided a press conference earlier. The sheriff of Los Angeles County, the Los Angeles County Sheriff's Department, talking about a number of different things, specifically the curfew and looter, saying the press would be allowed and officials would be allowed, but no people would be allowed, and they could be fined up to $1,000 for traveling in that area. We are also following that camera right there on the left side of your screen. That's on the interstate here there in Jonesboro, I should say, where you can see snowy, not a lot of traffic on the roads, a lot of businesses and schools closed today. Brooklyn Public Schools closing yesterday, and you can see snow still continuing to fall down on that camera. People getting out if they have to go to work, if they are an essential worker, essentially. but pretty much a snow day for many people. This snow not expected to melt tomorrow, maybe minimal melting on Sunday if the temperatures stay according where they currently are. And throughout the week it does heat up, so the snow will eventually melt. I'll just tell you, the snow's really pretty on the first day, but when it gets to the second and the third day, it turns brown, gets muddy, gets so ugly. So, flake and stay nice and white for just a little bit since it's not going to melt as quick as we've seen some other events. Schools, again, as I was saying, across Northeast Arkansas already canceling. What we're going to do here, just in talking about everything that you need to know about the weather and things of that nature, but the TikTok versus the Attorney General argument's actually pretty interesting. TikTok saying that this would take away Americans' First Amendment rights, while the prosecution in this case, the Attorney General's office, the Department of Justice, saying this has nothing to do with Americans' First Amendment rights, rather that the algorithm and recommendation search engine is not controlled by TikTok. TikTok is an American-owned company, but ByteDance, the parent company, is a Chinese-owned company. So what they are claiming is that, what the government is claiming here, is that TikTok's algorithm and search and recommendation search engine is not controlled by them, leading to possibly having more than 170 million Americans' information leaked to the Republic of Chinese government. So that is something that has been brought up in this case, and oral arguments are still ongoing. I will note that according to IJ of Arkansas, there are also a number of incidents. I wonder if I can break them down. I'll just do this on my phone here because I know it's going to be a little bit, maybe not. Maybe I can do it right here, but I know it might be a little bit easier to do it. It might be a little bit easier to do it on my phone, but I just realized the app is not officially downloaded, so... Okay, I'm opening it now. So there are a number of incidents, including one right here in Jonesboro. I believe there might be actually a camera near Bay, actually. The closest camera that we can get is actually right on top of it. This is near the Nestle exit, and there has been some type of incident. Not much to see there. I'll move it. Stand by. I want to make this look pretty, so I do have to do it this way. This is what's hard. So essentially how I have this set up is my computer is one screen, and then what you guys are seeing is an entire other screen. So it's actually kind of complicated to... I have to tap on it, then I click escape, obviously, to get it to unfull screen, and then I have to kind of watch where my mouse is very closely. I'm going to go down to where this accident has occurred. It's the Nestle camera. Right down here, I see it. So this, according to the information on this accident, and I can go full screen for you guys for just... well, actually, what I'll do here is I'll put the camera... I'll full screen the camera for you guys, and then I'll read what the information says according to IJ of Arkansas right here. So this is a camera, exit 36 on Interstate 555, which is the intersection that we've kind of been taking a look at this entire time. And what it shows here is that it was a single vehicle accident. And I'll go full screen for you guys for just a moment, and what you can see there is that what you see there is police pulled over on the side of the road with a single vehicle. We don't know exactly what occurred. We just know it was a single vehicle accident. And this all occurring on the northbound left shoulder of Interstate 555 right before, or right after, I should say, maybe right before exit 36. So that is something to watch out for if you're heading out. You see another police now pulling up behind them. Another police vehicle now pulling up behind that vehicle. That is something that we will continue to monitor. I'm Jackson Mitchell here in Brooklyn, Arkansas. You see that iDrive Arkansas camera on the other side of your screen. I wouldn't say too big traffic delays. I know there are a few other incidents. We also have a camera, a new camera that we can bring you from right here in Brooklyn. You are hearing me correctly when I say that. That is right there at Highway 49. You guys want to see that camera? I do too. We have a new camera that we were able to bring you that brings you right here in Brooklyn to a place that honestly hotspot for accidents, but also everyone knows it when you talk about where Brooklyn is and what Brooklyn is. So let's go full screen out to that. And actually what I'll do here is, this allows me to, it lights it up so I can see it better. So exit out of that. Now let's go up here to the iDrive Arkansas camera in Brooklyn. It is set as kind of a temporary camera, but it could turn permanent. Let's go. Get a look at that camera as it is a snowy day here in Brooklyn. You can see traffic there. We'll take you back out there. You can see traffic there. Out and about. That is a look at the camera there in Brooklyn, the iDrive Arkansas camera. Honestly, I can't lie, I did not know that was there. I don't often check iDrive Arkansas too often, but I know I check it a little bit. There we go. There's the iDrive Arkansas. So that's via Arkansas Department of Transportation. That is right there where you can see snow still coming down in Brooklyn, and that is true for pretty much the entire city, as I was saying before. And that's really just because snow's still coming down, of course, because in the camera displaying it, and it's really, I think that camera is at a beautiful place. And that because that place, first of all, that's right here in Brooklyn, we actually finally have a camera that I can shoot right to when we're talking about accidents there. So that should be something used if there is ever an accident that does in fact occur right there on Highway 49, there at the intersection of Brooklyn School Street and Brooklyn School Road on that other side is what it turned into. So nice to have that camera to look at. Now 2 hours, 11 minutes of our live coverage. I'll tell you, I can peek outside for you guys, and I'll tell you what it looks like here in Brooklyn. So for me, I have a window actually right by my set. And the snow is still coming down pretty heavy, actually. I had a video from earlier this morning that I believe we now have it uploaded and no, we do not. I had a video that I made earlier this morning, and I thought I might have had it uploaded and ready to bring to you guys, but I do not. Essentially, in that video, I was talking about the snow. It was real because last night I had went to bed because I knew I was going to have to get up early to cover the Trump and the Supreme Court arguments and things of that nature. So I had went to bed at about 12, and when I woke up, it was, pretty nice amount of snow, but I can tell you it's only gained since then. You can see the roads here in Brooklyn pretty clear, but I don't know if that's because there has been officials that have come out or what, or just enough vehicles driving on the road. That's something that we've often seen, is when you are constantly having vehicles driving on a road, the snow often not staying on those roads. That's something key to talk about. As we continue our coverage on this Brooklyn News Special Report, the Supreme Court still continuing oral arguments. We will listen back in soon to them. I just wanted to check in on a look at everything else. So we're going to be monitoring this iDrive Arkansas camera there in Brooklyn, and keep and continuously monitoring that and much more. What I do want to do is listen back into the Supreme Court oral arguments that are ongoing for just another moment or two. Stand by for that. Again, we were hearing arguments continuing from the defense saying that TikTok should not be banned and that it would take away Americans' First Amendment rights. That's essentially the entire argument from those that support the application, while the government, who has been kind of not a part of it, says that ByteDance, which is a foreign entity, is that company puts 170 million Americans' information at risk of possibly being stolen and kind of used for the Republic of China. I want to listen back in, though, for just a moment to oral arguments once again in the Supreme Court. As we take a look live there.
That you're a little bit, I think you've just given your thing away, because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will, that concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based, or that it looks anything like the kinds of laws this court has previously said are content-based. The court most recently in City of Austin said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. This law was passed by broad bipartisan majorities in both houses of Congress, and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. Instead, the court has said it warrants closer consideration. And here, if you look at the US speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
It's hard for me to think of situations, maybe they exist, where our classification based on speaker is not viewpoint or content-based restrictions. I mean, somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now. We don't know what he's going to discuss, but whatever he says is bad because Joe is a bad person. I mean, that's viewpoint and content-based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign adversary wants to take against us. And I don't think a concern with trying to ward off that capability.
Why isn't that viewpoint or content still? We don't know what the content's going to be, but we know it, Joe is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter, the specific viewpoints, but the technical capability of a foreign adversary nation to use a communications channel against this.
I guess I'm just struggling. How covert content manipulation isn't content-based restriction?
So
I mean, the
again,
word,
because
it's kind of hard to avoid the word content. And it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny. And as the DC Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here, and that have a longstanding correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's a less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone, and on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Andersen. Why isn't that a less restrictive means available?
So I'm surprised to hear petitioner offer that up today, because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the US subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor. And you don't have to take my word for it. You can look at the specific terms of the National Security Agreement that ByteDance itself proposed. The relevant definition of the accepted data is at JA 239 to 240, and it references categories of information that would, of necessity, technological necessity and business necessity, have to flow back to China. And the relevant categories are in the sealed appendix, but I would really encourage the court to look this up because it's eye-opening. It is at the Court of Appeals sealed appendix 249 to 252 and 254. If you look at that information, it was a wealth of
Okay, you have been listening into arguments from the Supreme Court there on the TikTok ban that could be coming, according, it appears, I'll just say this, it appears that the court is in some way, and I'll just say this, not signing with TikTok. That's just so far. While we do hear from the prosecution, from, I guess I wouldn't say the prosecution, but from those, the government officials that are arguing, she is saying that this is a threat, and they're asking her, I guess you could say, a tinge question, similar to what they're asking the defense, but right now, the questions and the attitude that the court is taking towards this case really makes me begin to think that they are not siding with TikTok. And I've heard multiple different people say multiple different things, saying, saying things like, it's unusual for the court to not side with the government, especially when it comes to First Amendment issues. Now, we know that if the court, it depends how fast the court can release an opinion, and if they release opinion in the next 9 days, we will, of course, I'm sure, depending on when that happens, what I'm doing, I'll break right back in as I always do with the BN special report and cover that, the entire opinion on the TikTok application. But the court right now not seeming to side with TikTok on this ban, but prosecution right now making their arguments about all of this, and we will bring that to you all. We will continue our breaking news coverage of these arguments at a later time, but that is going to do it for me on this BN special report. Let's leave you out with the shot here at the intersection of Highway 49, looking out towards Paragould, actually. You can't see too far because of the snow. But again, that is going to do it for me on this Friday. Have a beautiful rest of your day and enjoy that snow if you're right here joining me in Brooklyn. I'm Jackson Mitchell. Have a great day.